Welcome back to Counting to Five, a podcast about the United States Supreme Court. In this episode, I'm going to preview a case called Ohio v. American Express, which is going to be argued on Monday, February 26th, 2018. Now, this case, Ohio v. American Express, is an antitrust action brought by the United States and a number of individual states against American Express. And the question that the Supreme Court is going to be grappling with in this case is, how does the antitrust concept known as the rule of reason apply to two-sided markets? Now, there's a lot there. So there's two basic questions from that. First, what is the rule of reason, and what is a two-sided market? So I'm going to step back and try and explain both of these, and that'll help us understand what the court is really being asked to decide in this case. So antitrust is the law aimed at preventing monopolization and promoting competitive markets. And the main antitrust statute is the Sherman Act, which was passed way back in 1890. And the Sherman Act has several different provisions that do different things. The most important two are Section 2 of the Sherman Act, which deals with monopolization, when some company controls too much market share in a particular market and becomes a monopoly power. That's not an issue in this particular case. It's Section 1 is what's at issue here. And that deals more broadly with anti-competitive behavior of various forms. Now, the language of the Sherman Act, of Section 1 of the Sherman Act, is very broad, kind of general language. So this is how Section 1 reads. Every contract, combination in the form of trust or otherwise, or conspiracy, in restraint of trade or commerce among the several states or with foreign nations, is declared to be illegal. So you can see that this is very broad language. It just says that every contract in restraint of trade is illegal, but doesn't define in any way what makes a particular contract in restraint of trade. So it's been left to the courts for over a century now to try and sort this out, and a number of through various cases since it was passed, the courts have set down various rules and tried to establish what it means for something to be a illegal restraint on trade in violation of the Sherman Act. And violations of the Sherman Act can be grouped into kind of two categories. There are some things that are called per se violations. These are things that are automatically illegal, regardless of or without needing to prove the specific anti-competitive harms in a particular circumstance. And this usually deals with certain arrangements between competitors. These are often referred to as horizontal restraints, and these are when you have multiple competitors in a particular market. If they, for example, agree between each other to fix prices, to agree on set prices, or if they agree to carve up a particular market in a certain way so they're not competing against each other head to head. These are the types of horizontal restraints that are just automatically illegal. These are per se violations of the Antitrust Act. But there's a number of other types of arrangements between businesses. This usually deals with what's known as vertical restraints, and this is arrangements between, for example, a manufacturer and a distributor, or between a distributor and a retail outlet or something like that, where they're not direct competitors. They're just two different levels of the supply chain. And in those type of cases, there's a different rule. These aren't per se illegal. If you had arrangements between, for example, a manufacturer and a distributor regarding where that distributor is going to be allowed to distribute the product or what prices they're going to charge, things like that. These are not automatically illegal. And the reason for this is economists who have studied these types of vertical restraints have shown that in many cases, these types of vertical restraints can actually promote competition. Something that may be a restraint as between a particular manufacturer and a particular distributor may create conditions that encourage competition by differentiation or other types of competition between direct competitors. And so these are governed by something known as the rule of reason. And the rule of reason is just basically a method of it's another name for the way the courts try to balance the pro-competitive and anti-competitive effects of these vertical arrangements. And the way the rule of reason works is there's what's known as a burden shifting framework. The way this plays out in litigation is you have a kind of a multi-step process. And it starts out with the plaintiff having the burden of proof to demonstrate that there's anti-competitive effects. So the plaintiff here, this would be the governments involved here, so the states or the federal government who are alleging that there's an antitrust violation by American Express. They have the burden of demonstrating that there are anti-competitive effects to the actions that they're complaining about. Once they've met that burden and shown that there are anti-competitive effects, then you move into step two. The burden now flips to the defendant here. So here, American Express, and American Express would have to demonstrate that there are in fact pro-competitive effects to the arrangement. And then if they are able to do that, then the burden once again flips back to the plaintiff, and the plaintiff has to show that those pro-competitive benefits could have been achieved without the complaint of anti-competitive restraint, so that there was a method of achieving those same pro-competitive effects that wouldn't have involved the anti-competitive restraint. And if they can do that, then they've demonstrated that this is illegal under the rule of reason. So it's this kind of three-step process where the plaintiff has to start out by demonstrating anti-competitive effects, and then the defendant can come back and justify it, and then it goes back to the plaintiff again. So what's really at issue in this case, this American Express case? The issue is something that's referred to as the anti-steering rules from American Express. And the way this worked is American Express has relationships with the merchants who accept American Express as a method of payment in for their stores or businesses. And American Express, as just one of their terms, their contract terms with these merchants, they have what's known as the anti-steering rules. And what this does is it prohibits any merchant accepting American Express from basically encouraging customers to use a different card other than American Express. It prohibits them from expressing a preference, telling customers that they prefer if they used, for example, Visa or MasterCard. It prohibits them from offering discounts or incentives, so it's some discounted price for using Visa instead of American Express. And it also prohibits them from disclosing to customers the costs of borne by the merchant of American Express versus, for example, Visa or MasterCard. Now, what's going on here is American Express is generally is the highest cost card to merchants. So when someone uses a credit card, a customer uses a credit card at a business, a part of the fee that's the part of the price that's paid by the customer is paid onto the credit card company, so American Express in this case. And that fee that is charged, it varies between cards, and it varies. There's a lot of different factors. Different industries, the credit card companies charge different fees to, but American Express is generally the highest cost card. And this is just a part of American Express's business model, in that they try and position themselves as the premium card that has higher net worth customers who tend to spend more money, but they charge merchants a higher fee to accept the card, and then the money from these fees can be then used to provide more benefits to the customers and allow them to attract these customers in. But American Express doesn't want the merchants discouraging customers from using their card, and they don't want the merchants trying to, or they don't want customers to kind of see the cost that's being paid through to American Express on these, because I think of a fear that this would it might prompt customers to use one of the cards with a lower cost to the merchant. So American Express has these rules, and there have been challenges to these rules. There were similar challenges to similar rules that were in place by Visa and MasterCard. So there's been litigation against the various different credit card companies for the way that they have various anti-steering or non-discrimination types of rules. But this case is specifically focused on American Express. And the argument here is that this is anti-competitive because it reduces price competition that would help to reduce these merchant fees. If merchants were able to steer customers toward their lower cost cards, if they were able to say, well, we accept American Express, but we'd really prefer you use Visa, or even to offer certain discounts to customers to use Visa, that would put some pressure on the credit card companies to compete in terms of these merchant fees. But because the customers are insulated by this anti-steering rule from differences in cost to the merchant between the cards, then this price competition doesn't really happen. So what happened in this case is the district court, in this case, found that the anti-steering rules were anti-competitive under the rule of reason. And they said the relevant market here is the market between merchants and credit card networks for providing the credit card processing services. And they said that these rules were anti-competitive in that they reduced or eliminated to a large degree this price competition on their merchant fees. Now, the argument against that, and this came up in the Court of Appeals decision in this case, the argument is that American Express is involved in something that's known as a two-sided market. Now, a two-sided market is a term for a situation where a company is an intermediary between two different markets. And here the idea is that credit card companies don't just have a relationship, a market relationship with the merchants. They also have a separate set of relationships with the consumers who carry the American Express cards. And the issue, the argument is that you can't look at just one side of this market, at these two pieces to the exchange, the relationship between the credit card company and the consumer, and the credit card company and the merchant. Those two relationships they're just wholly interdependent with each other. And you can see easily that each side of this market benefits from the existence and the size of the other side of this market. Cardholders want a large merchant network. If you carry an American Express card, then you want businesses to accept American Express. A card doesn't do you much good if there's very few places that will accept it or take that card. On the other hand, merchants want there to be a lot of cardholders. They accept these credit cards in hopes that it's going to drive more business to their stores, and credit card holders may be more willing to spend money or spend more money than people paying just in cash. And some people may not want to go to stores or may not buy as much if it's a business that they can't use their credit cards at. So they want to have a lot of card holders holding the cards that they accept. Now, in theory, something that has anti-competitive effects on one side of this two-sided market could have, at the same time, pro-competitive effects when looking at the system in its entirety. So here, merchants obviously would like to have lower fees that they're paying on each credit card transaction to American Express. But cardholders, on the other hand, want the benefits that come from using their cards, incentives and benefits that they receive from using a card. And those benefits are funded, at least to some degree, by the fees that are being paid by the merchants. And so you may, in theory, you may encourage, and one way to look at it is any benefits that are being received by cardholders. So special services provided by the cards, insurance type functions, or things like points that go toward travel or cashback or any of the other various things that are offered by credit card companies. Those benefits, credit card companies compete with each other in terms of offering those benefits. And those benefits are essentially reduce the cost of using the card by the users. So it's a form of price competition between the credit card companies by offering bigger and more valuable benefits. So the argument is that by having this rule which results in higher fees from merchants, that can actually enable the competition on the other side of the market, which drives down prices for consumers in the market for a credit card to use for their purchases. So what happened is this went up to the Second Circuit Court of Appeals. And the Court of Appeals held that the rule of reason analysis has to look at the entire two-sided market. That you can't just consider one side of a market when you're looking at whether something is pro-competitive or anti-competitive. You need to consider, so in this particular case, it wasn't enough for the district court to just say this has anti-competitive effects as in the market for between the credit card companies and the merchants. You need to also consider the cardholders in the analysis. And they said basically that the higher prices charged to the merchants enabled higher and better cardholder benefits. That increases competition in the cardholder market. So that is a pro-competitive benefit. And so the Second Circuit reversed the finding in the district court. So now the court has come up to the Supreme Court, and the question here is just how does the rule of reason analysis apply to these two-sided markets? So who was right about this? Can the rule of reason analysis be confined to one side of a two-sided market? Can you look at that relationship between credit card companies and merchants and look at that particular market and say, yes, this has an anti-competitive effect in that market, so therefore this is, this can fail the rule of reason, or you're required to look at both sides of the market, look at the whole market. So that's one issue that's tied up in this. Just the basic question of what's the scope of the market that you consider when you're looking for pro-competitive and anti-competitive effects. Is it just the one side of the market or the whole two-sided? That's one piece of it. But the other question is about this burden shifting framework under the rule of reason. So I said before that step one of the rule of reason requires the plaintiff, so the person claiming that there's an antitrust violation, it requires them to demonstrate that there's an anti-competitive effect based on whatever the challenged practice is. So the question here is it enough under that step one? So just to get past step one, to get to step two where the burden shifts to the defendant, is it enough just to show the anti-competitive effect on one side of the market, like was argued here with the anti-competitive effect on the merchant fees? Or is the burden in this step one, is the burden broader than that, and the plaintiff has to show anti-competitive effects on the market as a whole in order to do this? And the Second Circuit said it was the latter, said that just to satisfy that step one of the rule of reason, it wasn't enough for these plaintiffs to show that there was an anti-competitive effect on the merchants. They had to show that anti-competitive effect applied to this two-sided market as a whole. And so the plaintiffs here say that the Second Circuit just is wrong about that it's enough to show that there's an anti-competitive effect on the merchants. And really, that should be enough to shift the burden. And then even if you're going to consider both sides of the market, it should be American Express's burden to demonstrate that it isn't anti-competitive when you take into account the entire market. So that's kind of the legal issues that are involved here about how this rule of reason applies in these two-sided markets. Now, there's also some factual disputes going on between the parties. The plaintiffs argue that even under this whole two-sided market analysis, the anti-competitive effects on the market as a whole have been demonstrated, and there's enough evidence in there to show that this violates the rule of reason, even when you look at this entire two-sided market. And of course, the American Express disputes that. But it's not clear whether the court will even want to get into those kind of factual issues and may just stick to the legal issues about how to apply the rule of reason and this burden shifting framework. So that's the basics of Ohio v. American Express. And again, that case will be argued on Monday, February 26th, and an opinion could come down anytime between then and when the court wraps up its term at the end of June. So that's it for today. Please subscribe to Counting to Five on YouTube or your audio podcast app of choice. For timely coverage of the latest developments of the court, please check out Counting to Five's weekly YouTube live streams, where you can ask your own questions in the live chat. These are being broadcast every Thursday night at 9 p.m. Eastern Time. We're running these at a regular time every Thursday night at 9 p.m. Eastern. But please check the Counting to Five YouTube channel to see when the next scheduled live stream is, in case we have any changes to that schedule going forward. And I'm always looking for feedback. Please leave a comment or send me an email at mike@countingto5.com. And thank you for listening. This has been Counting to Five.